السلام عليكم ورحمة الله تعالى وبركاته. بسم الله الرحمن الرحيم. الحمد لله رب العالمين وصلى الله وسلم وبارك على سيدنا ونبينا وحبيبنا وقرة أعيننا محمد وعلى آله وأصحابه وأتباعه إلى يوم الدين. اللهم فقهنا في الدين وعلمنا التأويل وألهمنا بفيض فضلك رشدنا يا رب العالمين. Alhamdulillah. In our lessons on Multaqa al-Abhur, we're now in part 2 of the current lesson. We looked at this important issue of seeing rooms of a house and what's the fiqh related to it. You can review part 1 regarding this and why the fatwa is on the position of Imam Zufar. And they said this is اختلاف عصر وزمان وليس اختلاف دليل وبرهان. This difference is one of time and place and not one of proof and evidence. Okay. So خيار الرؤية. Then he tells us رحمه الله تعالى, قال الإمام إبراهيم الحلبي رحمه الله تعالى, that وإن رأى بعض المبيع, if one sees some of the item of sale, فله الخيار إذا رأى باقيه. If one sees some of the item of sale, one still has the option of خيار الرؤية if one sees the rest. And this is seeing some of it that is not sufficient to know the rest. Right? So something, seeing a little of it, you saw some of the sugar. You don't have to see all of it, but you only saw some part of the car for some reason. They only showed you the front. You have to see the rest of it. And the ibra is العلم ما يحصل به المقصود. Knowledge of that which the usage of the item is understood by. Okay. وما يعرض بالنموذج كالمكيل والموزون فرؤية بعضه كرؤية كله. And that which is sold by sample. Right? By sample, like the things that are sold by volume, كيل, or weight, al-mawzoon, seeing some of it is like seeing all of it. فرؤية بعضه كرؤية كله. So there's a few issues here. وفيما يطعم لا بد من الذوق. And in that which is eaten, you have to taste it. So if you're buying sugar and they say this is quality X sugar, then you don't know how do you know the sugar? By tasting it. Right? And of course, what if the rest of the sugar is not the same quality? Then this would be خيار العيب. Right? Or خيار الوصف, depending if it reaches the level of عيب. And here in Majma' al-Anhur, he gives many examples of these issues. So, namudaj, things that are sold by sample. Okay. Then, what about agents and messengers? Okay. So there's two different concepts. There is the wakil. The wakil is acting on your behalf. Right? So they say تصرف الوكيل كتصرف الأصيل. The actions of the agent are your actions in that which they've been authorized, as opposed to the Rasul. Okay? The Rasul is someone who's carrying a message for you. They're not acting on your behalf. They're just conveying, I want to buy this. Right? So there's a difference between the agent and the messenger. ونظر الوكيل بالشراء أو القبض كاف. The inspection of the agent, whether they're the agent to buy or the agent to take possession of the item after it was bought, is sufficient. Right? Because they're acting on your behalf. There's a good discussion here in Majma' al-Anhur again. And they give example of what. But then he says, rahimahullah, la nadhar rasul. But the inspection of the messenger is not yours. The messenger is hamilur risala. He said, they've gone to pick up the item on your behalf, but they're not your agent. You just ask someone that, he's sending a message that to pick it up. So, according to Abu Hanifa, the messenger, their looking is not like the looking of the purchaser. وعندهما هو كالوكيل. But according to Sahibain, his looking is like the looking of the wakil. And the wakil here, the Rasul, is the Rasul who has been authorized for qabd. But the basis in our madhab is the position of the Imam. Why? Because the agent, right? Because Abu Hanifa bases transactions on caution. The agent is acting on your behalf. So they've been given the right to act on your behalf, and part of your rights go to him with respect to that transaction initially. Then they're ascribed to you. So his inspection is like your inspection. But the Rasul, they're just running an errand for you. They don't have a choice. And here will be the Rasul who is taking qabd, taking possession of the item. Pick it up. But they're just running an errand. You've not authorized him to have this judgment. Okay. So this is on agents and messengers. Okay. What about the blind buyer? And what about real estate? So he says, because khiyarul ru'ya, its basis is ru'ya. The blind person does not have ru'ya, does not see. So the fuqaha differed. That can the blind person buy and sell? Because how can they inspect the item? So he explains, وَبَيْعُ الْأَعْمَى وَشِرَاؤُهُ صَحِيحٌ. In our madhab, the buying and selling of a blind person is valid, whether for themselves or for another person, i.e. as an agent. And he says, وَلَهُ الْخِيَارِ إِذَا اشْتَرَى. And they have the option of cancellation when they buy. And they would, so they would appoint someone to, right, to inspect the item on their behalf and have it described. Someone trustworthy to describe it to them. وَلَهُ الْخِيَارُ إِذَا اشْتَرَى. Right, so they have the option of inspection when they buy, and someone they trust would describe it to them, for that. وَلَهُ الْخِيَارُ إِذَا اشْتَرَى وَيَسْقُطُ بِجَسِّهِ الْمَبِيعِ. And it would be lifted in the things that don't require seeing, such as by feeling the udders of the cattle, for example, the jass, أو بشمه, or by smelling it, أو ذوقه, or tasting it, فيما يعرف بذلك, in the things that are known by these matters. ويوصف العقار له. And property would be sufficient to describe the land. Right, so there, the khiyarul ru'ya would not be established beyond these things, because these are sufficient to be considered to have seen the item. Right? So these are the ahkam of the blind person. Their transactions are valid. Why? Because they're mukallafun muhtaj. They're morally responsible. Right? Aqil baligh. And they have responsibilities both to Allah and to creation. And they're muhtaj. They have needs. So if you weren't to validate their sales, there would be harms. Tawakkalna ala Allah. And then he says that ومن رأى أحد الثوبين فشراهما ثم رأى الآخر فله أخذهما أو ردهما. Right? So someone who buys لا رد أحدهما. So whoever sees one of two garments but bought both of them, and then saw the other one, right, which is his right, so he has a khiyar. But what is the khiyar? فَلَهُ أَخْذُهُمَا. He can take both or return both. He cannot take one and return the other one. Why? This is according to Abu Hanifa, that if two things enter into a transaction, if it's one contract, then the contract is considered as one unit. This mas'alat ta'addud as-safqa. Right? According to Abu Hanifa, if you buy if two or more items enter into a transaction, it is one transaction, and you cannot separate its parts unless there's mutual agreement, unless there was an ijab and qabool for each item separately. Right? So this is according to, so if you, in this scenario, saw one of two garments that you bought in one contract, but then later, after the contract, you saw the other, you have the choice of taking both of them, because it is one contract, or returning both. You cannot just return one of them. This would be considered tafriq al-safqa, breaking, the contract, taking part of the contract and not taking the part, because that goes against the principle of إلا أن تكون تجارة عن تراض منكم. تماما. Because the seller may not be satisfied with you just keeping one. Very often people bundle things together in one transaction and they reduce the price. Each thobe, were to be sold on its own, was $50. But when you put them together, it was less. So he ends up getting hurt by this transaction. Okay. Then he tells us that what if the item seen changed? وَمَنْ رَأَى شَيْئًا ثُمَّ شَرَاهُ فَوَجَدَهُ مُتَغَيِّرًا تَخَيَّرًا. If someone sees an item and then purchased it, and then thereafter find it different from how they had seen it, they have the option of inspection. Now there's a key proviso here. He says, وَمَنْ رَأَى شَيْئًا. Right? And the key condition is قَاصِدًا لِشِرَائِهِ. Someone saw an item or inspected an item, and it's not any seeing, but قَاصِدًا لِشِرَائِهِ, with the intent of purchase. Right? With the intent of purchase, and then found it different from how they had seen it. So, you inspected a car and it had leather seats, but when you bought it, there was other seats in there. They were not the leather seats. So the original ru'ya, when you inspected something, right? And this qasidan li shira'ihi is important, right? So a smart shopkeeper would distinguish just people coming in, but for example, for valuable items, they may want to specify that, okay, that if you want to look at it in more detail, okay, you can inspect it if it's for the purpose of purchase. So that way, the person would deal with it with that degree of seriousness. Tamaman. So in this situation, whoever sees something, the condition here, don't miss it. You can find it in both the commentaries. Whoever sees something, intending to purchase it, then they purchased it and found it different from how they'd seen it before, right? They have the option of cancellation. So the principle here also is that if you see something before the actual sale, but you had seen it with the intent of purchase, and it is as you saw it the first time, you don't have the option of cancellation therein. A smart seller, someone selling jewelry, etc., your things are on general display, that's not seeing. But the inspection to purchase, you say, okay, you want to see that jewelry? Okay, the smart seller, the ba'i', that's smart, knows their deen, would say, okay, are you intending to, do you have an intent to purchase? Yes, okay, here we'll show you the jewelry item, etc. So then afterwards, they say, yeah, I'll take that one and that one. And they didn't see it at the time of purchase because they'd already seen it, and it's exactly the same, then they don't have the option of inspection because the previous ru'ya is a ru'ya if you saw it for what purpose? قاصدا لشرائه. Okay, even if some time passed. تخير. وإلا فلا. Right? Otherwise not. Meaning that if the item did not change from when they had seen it previously, then they do not have the option of cancellation. لأن العلم بالبيع قد حصل بالرؤية السابقة, because knowledge of the item happened with the previous inspection if it was for the purpose of sale. Okay. وإن اختلفا في تغيره فالقول للبائع. And if they differ as to whether the item has changed or not, then the word of the seller is taken. Why is the word of the seller taken? Because al-bayyinatu ala al-mudda'i, the one claiming something has the burden of proof. We know the hadith, it's in the 40 Nawawi, that al-bayyinatu ala al-mudda'i wal-yaminu ala man ankar. Right? So the one making a claim has to provide proof. And who's making a claim? It's the mushtari, the seller, the buyer, the mushtari, the buyer is claiming that the item isn't as I saw it. So they're making a claim. They have to have proof. So if they're smart, when they saw it first, they take a picture, for example. So if it's different later, because they're going to pick it up, they're going to make the transaction in a rush. If it's different, say, look, this is how it was when I inspected it. Okay. So إذ اختلفا في تغييره فالقول للبائع. Right? Because واليمين على من أنكر. But القول له لكن مع اليمين. So the word of the seller is taken with their oath. With their oath. تماما. وإن في الرؤيا أي وإن كان اختلافهما في الرؤيا, and if they differ as to whether he's seen it or not, then the buyer's word, the mushtari's word is taken. Same principle comes to apply here. البينة على المدعي واليمين على من أنكر. It is the buyer, the mushtari, who's negating having seen the item. That's the presumption. So his word is taken, but with an oath. Oath is by Allah, so it's meant to prevent people from making false claims. نسأل الله اللطف والتوفيق والتيسير والعافية. Okay. And then we have another issue. What about mixed bundles and other matters? ومن اشترى عدلا ومن اشترى عدلا زطي فباع منه ثوبا أو وهب وسلم فله أن يرده بالعيب لا بخيار رؤية أو شرط. Whoever purchases a bundle of commodities, of items, right? Right? Such as, cloth, zutti cloth, which is cloth from a part of India that good cloth used to come from. So one bought a bundle of cloth and sold, and after buying it, sold one or more pieces of cloth after taking ownership of it, or gifted it. And wasallam, and gave the gift to the person. So that the ownership transfers. Then he discovers a aib. فَلَهُ أَنْ يَرُدَّهُ بِالْعَيْب. They can return it by aib. Right? They can return the bundle for a aib to protect his right, but he no longer has khiyar. Why? Because this was one transaction. You cannot return part of the transaction because the seller, the original seller, is harmed. He sold you a complete bundle of 25 items of cloth. You sold 3 and returned 22 and got the price. He would be harmed. This is again issue of tafriq al-safqa. This is one transaction. You can't break it up according to Abu Hanifa. But khiyarul aib would apply to protect rights. So that is khiyar al-ru'ya and that which relates to it. Next, bi'idhnillahi ta'ala, we are going to be looking at the khiyarul aib, option of defect. So we looked at defining the option of inspection, what triggers the option, when it lapses, what ends it before versus after seeing, what inspection is in different types of goods, al-ilmu bima yahsulu bihi al-maqsood. And next, bi'idhnillahi ta'ala, going to look at the option of defects. Wa sallallahu ala sayyidina wa nabina Muhammad wa ala alihi wa sahbihi wa hizbih wa akhiru da'wana and alhamdulillahi rabbil alameen wa barakallahu ta'ala fikum. Wassalamu alaikum wa rahmatullah.